to bring the same on record, well.
Which item?
Item 36. Supplementary. High level expense.
May I please, your Lordship? Lordship, I pray for listing of a criminal petition, Lordship.
When
It
did you
is,
file?
Lordship, it is a pending matter, all matter of 2021. It was last listed on 23, Lordship. Thereafter, it has not been listed.
26th.
26.
Next
Lordship, can it be on 28
You want on 28? It will be Sunday.
Sunday?
0 you want.
28,
28
28
Sunday.
Sunday. Lordship, can it be on 27 then?
Fourth
Oh,
Saturday.
Friday, fourth Saturday. Lordship, then in the first week of August, any day,
1st of August.
1st of August.
Right.
Lordship, similar for another matter, quashing petition, same, another matter on the same date. Obliged.
Please, Your Lordship, regarding item number 22, my lord. This case is conducted by senior advocate, Mr. Z. Kamar, my lord. He has some personal difficulty today, my lord.
Okay, later matter reach, we'll see. But not at this stage.
My lord, item number 11, my lord. Mr. N. Hassan is unwell, my lord. I've been asked to make this submission on his behalf.
Okay, there is some office note, later matter reach, we'll consider.
May please, my lordship. I pray for listing of a criminal petition, my lord. It was last listed on 30th of May, my lord. So kindly this matter may be taken up on
26th.
26th will be difficult, my lord. 29th.
Okay.
I'm deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 7. I have taken consent of the other side. The conducting counsel, Mr. S. Nawaz, is unwell today. So only for the day I pray for an adjournment.
Just wait for some time. Please file to the vote.
Take a listing of a pending criminal petition, Lordship. 2023 matter.
26th.
May I please, your lordship? I beg to mention that item number 30, my lord. Matter may be
13 or 30?
30.
Hmm.
Matter may be passed over for the my engagement due to some personal difficulties.
Later matter reach. Yes.
Lordship, I beg to mention item number 21.
Hmm.
Amicus curiae case, Lordship. My senior is not present.
Later matter reach.
In respect of item number 17, here the petitioner has already expired and the matter has become infructuous, my lord.
Okay. Mr. Sunil, just wait for a few minutes, we'll pass that on.
Lord, sir.
We'll let the mentions be over.
Lord,
We'll pick up your matter at the
May please, Lordship. May please to listing a matter criminal revision petition, Lordship. Maybe fix on tomorrow. But criminal revision filing number 6137.
Why tomorrow?
Tomorrow because NBWA issued, Lordship. By
Monday. Monday. Yes.
May it please, Lordship. Lordship, I beg to mention item number 28. Lordship, the engaged counsel is not keeping well today, so the matter will be taken.
Later matter reach, may not reach also if you take up some hearing long time. 85, I know. What number?
May I please, Your Lordship? Lordship, prayer for listing a criminal petition, Lordship. It was last posted on 25, but not reached.
24.
22 can be.
Not on 22nd, 24.
Obliged.
Petition.
And prayer be cancelled for the matter be as in for 2 weeks. Let's release the matter and wait 2 weeks.
What?
Adjournment prayer, sir.
No, no, it's not expired.
Oh, petitioner expired.
Complaint case particular.
Oh, okay. Very second, very nice. Hmm? 21. Okay.
6/20.
Do you have his death certificate or any?
No, my lord, the engaged counsel has over phone informed me.
When did he expire?
The date I am not sure, but he is also for the respondent, he is also, it is admitted, my lord, that the petitioner has already expired.
The sole respondent hearing. File a complaint petition before the London Chief Judicial Magistrate Bongaigaon against the petitioner and another. Stating that the accused persons, including the petitioner, involved in cheating, criminal breach of trust, and criminal conspiracy. And it was registered as CR case number 20/2012 before the Court of London Chief Judicial Magistrate, CJM Bongaigaon. London CJM Bongaigaon. After recording the statement of the complainant and making inquiry under section 202 CRPC. On 13/02/2012, to cognizance of the case under section 420 IPC against the petitioner and issued notice to him. Agreement says order to 13/02/2012 of the CJM Bongaigaon, passed in CR case number. The petitioner filed this criminal petition on 02/04/2000. The court on 04/04/2012 while issuing notice to the respondent. In the interim, state the further proceeding Take the proceeding of said CR case number 2012-20 of 2000 pending before the Learned Citizen Bangalore. Sorry, Bangladesh. Which is still in. Heard Mr. T. Chaudhary, Learned Counsel appearing for the petitioner. What's your good name?
BJ Mukherjee.
Bangladesh Citizens. Okay, so let's- During the deliberation of the matter, both the learned counsel submitted that the petitioner Sujit Rudra, son of late Lokhi Kanta Rudra, have expired during pendency of this criminal petition. That's this criminal thing in fact. The records of CR case number 20 of 2012 that was called for from the by order dated to return to the Court of Learned Chief Judicial Magistrate Bangladesh along with the return for registration. Yes. Both Mr. Chaudhary and Mr. Learned Counsel for the-
My lord, in this case, we have not received the copy of the IA. It was filed during the vacation ban.
These are subsequently filed because for staying the proceeding before the court below, because after this petition was filed for passing of the affair, in the meantime, during pendency of this petition, that such sheet was submitted and the court has taken cognizance of the offence. And issues on the, and this petition is for quashing of the affair filed by the respondent number 2, the affair is at page 14.
IA copy to the
In the Hana ATM.
IA copy will take.
And in the meantime, I filed the I also for staying the proceeding. Now that this petition. Affair is page 16. It's lost by one executive engineer simply alleging that the misskills have encroached upon some government land. No criminal, implementing criminal material is against the petitioner, nothing but no 420 is not disclosed in the affair. And he is also the authority, but I mean that civil suit is also pending in regard to the land in question, my lord. Title suit is pending that of annex, my lord, and court has given injunction also in this matter, my lord. Order is also here, annex is annex 6, my lord.
But Mr. I have the legal and counsel appearing for the petitioner oblique applicant, petitioners, oblique applicants. Also hard MS at Zahan additional. For the state as one number 1. And Mr. M. Biswas at counsel for the respondent number 2. The petitioner as an applicant filed the connected criminal interlocutory application paying I CRL bracket 618 of 2024. Praying for stay of the proceeding of here case number 127 of 2020 of PRC that 1255 of 2022 arising out of Karimganj PS case number 39 of 2020 involved in this criminal petition. From the records, it is seen that the petitioners have not furnished a copy of the said I number 618 to the council for the respondent. In view of the above, petitioners are directed to furnish copy of the connected I number 618 of 2024 to Mr. Ambitious Leonard Council representing the respondent during the course of the day, obtaining necessary acknowledgement from the copy of the along with the annexes. List on Monday next. Monday.
Well, it is an interim order by continue order. That is an interim order.
Interim order is already there, not to take any course.
That is-
Yes, next.
Wait, please, Your Lord. The 482 petition, my lord. I have come seeking quashing of the FIR vis-a-vis the proceeding of PRC case. The FIR, my lordship, will find at page 20, my lord.
Will it postpone, Hasil? Why did
Huh?
it get postponed?
Huh?
Postpone kya hosil ajile on Thursday?
Copy পোৱা নাছিল মই। চাবলৈ দিছিল।
Oh, okay.
Content of entertain of no, don't get that. I know, but I have not been covered. Okay, no, what is the I can forward no for you. Rejected will go to you. Just make it rejected.
My lordship. Well, in this matter, my lord, 3 persons have been named in the FIR, my lord.
Mr. Does take your seat.
My lordship.
Very good.
Notice it, sir. Okay.
Yes, Mr. Jahan.
Lordship. Medical report is of course in the favor of the petitioners. Lordship. Sixty-four to 13. Fourth petition also. From 64 to 18 बता दो. Oh, so it cannot be released further. Select the evidence available. Not involved. Gorgeous. প্রথমখনত কাম দিছিলে Leonard Pegu is his friend. Friend type. না কিন্তু 400টা তো অকল উঠালে সন্দেহটো অহা নাই নাই নেকি নাজানো দে
Borough. Okay, apply for it. Right, quality. Go through the FIR, then her 164 statement as well as the medical. And tell us
Her 161
164.
and 161 also. Her story is totally different in 164. 161, I will see once. See time on to be. Dushna Tai. Only 164. Purilu. 161 to Dushna Tai. Dushna Tai is very important. 161. Oh, was it? বলপূৰ্বক ভাৱে কোনে লৈ যায় তাইক? ইংৰাজী ইমান তাৰিখে 161 আছে।
ইংৰাজী 6/12 তাৰিখে সন্ধিয়া প্ৰায় 7টা বজাত মোক ঘৰৰ পৰা বলপূৰ্বক ভাৱে বাইক এখনত উঠাই লৈ
কোনে?
Initially in her affairs, she said that the accused persons forcefully took her away with the help of the other two accused persons. But in her 164, she statement that she of her own
On
and the
her
night
own, eloped with the other person.
accused number 1, the FNM accused number 1, and in the road she made the accused number 2 and 3. Then the accused number 1 and 2 left her, but the accused number 3, the petitioner here, took away her mobile
phone.
Then she shouted, but
People
she
came.
could not flee away from the place of occurrence. So he came and he took her to his house as per the 164 statement. And then, of course, what are her grievances that mobile was with him.
Returned.
And then he did not fetch her any rice or nothing to eat. Then later mobile was handed over to her and she had called her people from her house.
This is what.
That's what he said. And but during her stay at the petitioner's house,
Villagers.
he tried to commit rape on her, but he could not. That's what he initiated in 160. And then that's how proceeded. And that's why in the search sheet, since there was no such material against the FIR name accused persons 1 and 2, the names were dropped. And since there was a statement made by the victim girl that he tried to commit rape on her, charge has been pressed. That's the state.
161 also little different again.
So let the trial court decide to that extent, because you see, other things are there which you do not want to at this stage. There is no mention whether this particular petitioner was staying alone or there was none in his house or what.
My lord,
There
she
is
was taken
nothing is
to,
discussed.
She was taken to a
taken to
villager's
Numal
house.
Pegu's house.
One
Numal
villager's
Pegu
house.
for a
That is in the FIR.
No, it is in the,
164.
164 just.
Numal Pegu's house, she was taken.
no, 164 also, he did not take her to his own house. 164, he said, আমি পলাই যাওঁতে ৰাস্তাত সৈনচক লগ পাওঁ। তেতিয়া প্ৰিয়ানাথে পেগু আৰু ডেনিয়ে মোৰ কি পলাই যায়, এৰি পলাই যায়। তাৰ পিছত কোঠাল পেগু মোৰ মোবাইলটো লৈ যায়। তেতিয়া মই চিঞৰি দিওঁ, গাঁৱৰ মানুহ আহি পায়। মোৰ কোঠাল পেগুত এৰি যাব বিচাৰিছিলে। গাঁৱৰ মানুহ আহি যোৱাত সি পলাব নোৱাৰিলে। সি মোক নুমাল পেগুৰ ঘৰত লৈ যায়। That co-villager. নুমাল পেগুৰ ঘৰ টাপানিত হয়। সি মোৰ ভাত খাব নিদিছিল। এদিনৰ পিছত মই মোবাইলটো পালো আৰু মই ঘৰত ফোন কৰি দিলো। So he actually did not মানুহ আহি কি গাঁৱৰ মানুহ আহি মোক তাৰ পৰা লৈ আহে। কোঠাল পেগুৰ মোৰ বেয়া কাম কৰিব চেষ্টা কৰিছিল যদিও কৰিব নোৱাৰিলে। বেয়া কাম মানে
But there is no record because whatever the materials that was called for, because the case diary doesn't show anything that the statement of
Numal Pegu
was recorded in the 161.
not
Just find out. We did not see anything.
no statement, my lord, because charge sheet, my lord, only there are 4 witnesses. Numal Pegu has not been examined.
So this is victim.
Charge sheet, it is there,
Search sheet has been filed.
my lord. Page number 25.
Victim then Dulun Grain. এইটো কোন হয়? Dulu Gain. Statement of witness.
Page 25. Charge sheet. Josna Tae, Rakesh Tae, Dulumoni, TN, Jotin Dole. The 4 witnesses.
যতীন দলে এইকেইটা কোন হয়?
Ekita আছে একমাকিত 161.
The requirement under the law is that if the statement of the victim is consistent throughout, right from the investigation to the trial, then she should be believed. We need not go to the other evidences. But here, of course, the stories are different. It becomes little unbelievable.
You look into consideration at the 482 or it will be the trial court to look.
Trial court will see this is quashing now.
That's all.
Quashing. Because other evidence has to be looked into in that case. Then now here in the quashing petition, we need not go into.
May I submit?
Yes. We cannot having a roving inquiry here.
We cannot.
Under that circumstances, my lord, may I be allowed to make my submission? FIR was filed, my lord. FIR clearly stated, my lord, one Priyanath Pegu committed rape upon her in the road.
Prosecution proof. Where you are it?
Otherwise, ingredients. What
You are
is?
absconding, you are not appearing. That's why you have run here. Thing is, this you go and appear. That's all. Let the prosecution
Now
prove.
the honorable court will see whether it will be an abuse of the process of the court if this trial is allowed to proceed, my lord.
So
Because
it has not
my,
reached the trial stage. He can also fight during charge framing
yes,
time.
Sufficient times are there. Various stages are there before framing of charge. He will get a chance.
harassment,
Even the trial court may discharge him. from the
Discharge him.
materials available at this stage.
Trial is
but
yet
there
to
are
begin.
certain circumstances, my lord. This case, summons has been issued from the magistrate court.
You appear.
Hmm.
You appear.
Cognizance
So
is
my lord,
taken by.
my,
Because you appear thereafter, you might be teachers because the materials whichever is here
without,
will be available before the admits.
without going into the technicalities, my lord, with regard to the trial of the case, my lord. My case is very, my lord, specific. Number one, my lord, the FIR is wrong. Apparently, my lord, considering the medical report, because medical report clearly says that hymen is intact. And in the FIR, my lord, she has made categorical allegation only against one person. That is, my lord, one Priyanath Pegu. Then, my lord, in her 160, then FIR is, my lord, apparently, my lordship
Kuthal.
will see that there is no allegation against Kuthal Pegu.
Yes,
that-
pass on the record.
Lordship. The requirement of quashing as provided in Bhajan Lal's case is that no ingredients of the section has to be there. Those ingredients are there in FIR and all. Rest law will be taken care of by the trial court or during charge framing.
FIR, no ingredient, definitely.
No, committed rape upon you. That's about,
Priyanath Pegu, not Kuthal Pegu.
no. Accused number one, oh, Priyanath,
Priyanath Pegu.
Priyanath,
Kuthal
but
Pegu
under
is
the
separate
leadership.
allegation. Not a single lady, he attempted to commit. Entirely.
Charge sheet or I got hello.
No, I hate to 161,
Hmm.
164. A good day case to entirely based on 164 statement. Second, Supreme Court at a judgment of question. The charge sheet of the statement is কিন্তু আগৰ মেটেৰিয়েল খিনি যদি সাপোর্ট নকৰে তেতিয়া কিন্তু পাস কৰিব পাৰি মানি দেখাম পুৰা মেকিং বয়ফ্ৰেণ্ড বিয়া পাতা ভাবটা আছে ট্ৰিটমেণ্ট আছে
প্ৰিয়ানাথৰ লগতে
প্ৰিয়ানাথৰ লগত পলাই যাওঁতে লগ পাই পুৰা মেকিং
হাতাবলা কৰিছে
ফালতু পচন্দ
কঠিন কৰিব দিগদাৰ হ'ব চাৰ্জ ফ্ৰেমত হৈ যাব
কিন্তু সেইটো পৰীক্ষাটো
no cognitive offense is made of it. Yes, Bhajan Lal.
একটা কথা
First. First of all, it doesn't make out it was against bail. And he later took out a এক number it has not. Very education in first information report disclose a cognitive problem. Cognitive problem. It any of the and
Parliamentary. Puro.
জানিছেনে মন্দিৰ ঘৰৰ পৰা সন্ধিয়া ইমানমান বজাত পলুৱাই নিয়াৰ পিছত ৰাতি 10-11 বজাত 10-11 বজাত নেকি
এলিগেশ্যন মোৰ ভণ্টিক ৰিয়ানাক পেগুৱে ধৰ্ষণ কৰিব চেষ্টা কৰিছিল বুলি মোক কৈছিল ৰিয়ানাক পেগু নট টোটাল
মোৰ হেৰি তাইক ওলাই হঠাৎ কোন বজাত শ্ৰী প্ৰিয়ানাথ পেগুৱে ডেনি পেগুৰ ভণ্টিক এৰি পলাই যায় বয়সী ইমান কোঠাল পেগু মোৰ ভণ্টিক চিনি পায় মোৰ ভণ্টিক ঘৰত বাবে সমজাই দিয়ে কোঠাল পেগুৱে লৈ আমাৰ গাঁৱৰে ঘৰত থৈ যায় নহয় কিবা এটা আছে ৰাখি যায় দুদিন পিছত আমি ঘৰৰ মানুহে ভণ্টিক উদ্ধাৰ কৰো মোৰ ভণ্টিক প্ৰিয়নাথ পেগুৱে ধৰ্ষণ কৰিব
চেষ্টা কৰিছিল বুলি কৈছিল জানো
ধৰি চাই আছো উদ্দেশ্যৰে পলুৱাই আনি তাইক ৰাষ্ট্ৰীয় ঘাইপথৰ ওচৰতে কোঠাল পেগুৰ লগত এৰি থৈ যায়
সেই সময়ত উক্ত স্থানত শ্ৰী ডেনি পেগুৰ পত্নী উপস্থিত আছিল আমি গাঁৱৰ ৰাইজে শ্ৰীমতী জ্যোৎস্না তাইক শ্ৰী কোঠাল পেগুৰ লগত চমজাই দি প্ৰিয়ানাথ পেগুৰ ঘৰত চমজাই দিবলৈ অনুৰোধ জনোৱা কোঠাল পেগুৱে জ্যোৎস্না তাইক বাইকক উঠাই লৈ যায় পিছত আমি 2-4জন পিছে যাওঁ যদিও কোঠাল পেগু আৰু জ্যোৎস্না তাইক আমি টংগানীত লগ নেপালো পিছত জ্যোৎস্না টংগানী গাঁৱলৈ নুমাল পেগুৰ ঘৰৰ পৰা 2 দিনৰ পাছত ঘৰৰ মানুহ আহি ৰাইজে আহি নিজৰ ঘৰলৈ এই বুলি কয় আমি সোধ কৰোঁতে তাইৰ লগত প্ৰিয়ানাথ পেগুৱে বেয়া কাম কৰা এফআইআর পঢ়িব চেষ্টা কৰাৰ বিষয়ে একো কোৱা নাই
একো কোৱা নাছিলো। Independent witnesses are only these two, no?
সেইটোৱে নাই
Raketae,
দুলুমণি তাই যতীন
এইটো
তাই
হয়।
ৰাকেশ তাই
Rakesh তাইটো পঢ়িলো, no?
এইমাত্ৰকে পঢ়িলে ৰাকেশ তাই ইমানত বিগতসকল কৰিব চেষ্টা কৰিছিল বুলি মোক কৈছিল
আৰু দুলুমণি
দুলুমণি ইয়েন
কোন হয় এইটো? মই তেতিয়া ইমানদাৰিতে ওচৰত এজনী কান্দি শুনা পাই কন্দা কথা শুনা পাই ওচৰত ছোৱালীজনী গাঁৱৰ বুলি চিনি পাওঁ।
একেবাৰে গাঁৱৰ ল'ৰা এটা এইটো নেকি
লগত ছোৱালী গাঁৱৰে এজন ল'ৰা
এটা বিয়া
নহয়,
পাতিম বুলি
নহয়, চিনি পাওঁ যদিও একো নকলো। সেই সময়ত উক্ত স্থানত
সেই সময়ত ছোৱালীজনীৰ লগত এইটো নেকি
তই পঢ়িছ
মই আধাৰে লিখা
আচ্ছা একো নাই
সেইখিনি
এটা ইমান
সেই সময়ত ছোৱালীজনীৰ লগত
বিয়া
এটা ল'ৰা
ল'ৰা এটাই বিয়া
জনকে
পাতিব
ছোৱালীজনী ঘৰত থৈ আহিব নহয় টঙা
হয়।
গাঁৱৰ ল'ৰা এটাই বিয়া পাতিম বুলি ছোৱালীজনীক ঘৰৰ পৰা পলুৱাই আনিছিল যদিও উক্ত স্থানত তাইক এৰি থৈ
Yes,
পলাই
sufficient. Passing on.
In fact, the independent witnesses have not stated anything about this
But it's not
petition.
interfering. Let the trial court decide. You have a position 227, will be discharged. Why should you exercise that power here?
My lord, may I submit with
Yes.
regards to my lord why the honorable court, my lord, needs
Yes.
to exercise power under section 482.
Yes.
My lord, firstly, my lord, I would like to bring the lordship's attention with regard to the FIR that has been filed.
Yes.
FIR, my lord, the informant has categorically stated that Ek Nong Podokia
Yes, you have seen that.
my lord,
You have seen.
Ek Nong Podokia মোক মোৰ ঘৰৰ চোতালৰ পৰা মুখত টোপা দি অপহৰণ
Yes, you have read that, Mr.
my lord.
Das.
Then my lord, this FIR, her FIR, she has stated nothing about the present petitioner. Not a whisper against the present petitioner.
The response number 2. On 8/12/2018. Lodged an FIR before the officer in charge of Silapothar Police Station.
If I may just, the matter where a report had come from the superintendent that the person overstayed on concurrent and consecutive, that matter is on board as a last item. The lordship, if your lordship takes it up, because I've seen the case laws where I found that if the case is of the same transaction and two sentences are provided, it has to be concurrent.
Yes, there are judgments which for honorable judge's judgment. I'm also having it.
Even Justice Gogai's judgment also I've got.
You have seen. It has to be concurrent. It said,
Yes,
right.
lordship said it has to be concurrent, but then that Sunil Kumar is creating problem.
But there is another judgment.
Ah.
I have in my record. We'll get back to you. There are more backward before. Okay, 6. There it says discretion is also given to the High Court. Discretion has also given to the High.
Oh,
That
that I've
judgment by
not
the
read.
court. We'll give it to you.
Not.
And then it was decided. But otherwise, what the court said, I mean, the larger bench, if it is not mentioned,
If it is not mentioned, OIC or one is OM Charbian or OM Charian,
that's 3 judges judgment.
3 judges bench.
para 20 you'll get.
Yes. That was a case of 498A and 306.
Mm.
It was made consecutively, but, and yes, and it was referred to a larger bench. That is a larger bench decision.
There is a larger bench
Huh.
petition that you will get it at 2016 8SCC.
2000, yes. Otherwise, Om Charian is 2015 2 SCC.
That you will get it in 2016 8SCC.
Yes.
This is 1 to 5 judges bench. The full bench
Mm.
constitution, 5 judges bench.
Mm.
There it will get it at para.
Itu মোৰ পিছতে কৰি লওঁ।
Come to para 23. If you have the 2016 8SCC.
Lordship, if your lordship tells me the page number, because I
That
think
is 2016 8SCC 313.
313, lordship.
Because it differentiated 4 categories. One is multiple sentences awarded, none of them being life imprisonment. Second category is multiple sentences awarded, some being term sentences and 1 sentence of life imprisonment.
Acha.
Then thirdly, multiple sentences of life imprisonment only. Fourthly, multiple sentences awarded, some being term sentences and multiple sentences of life imprisonment. Now, wherever there is a life sentences, then it is life.
Then it is life.
Question of consecutive will not come. In that judgment, it is said that you come to para 23, page 3 to 5. Come to para 23. You read para 23.
Charian case is the 23 start.
Para 23. Parliament.
It started, maybe our paragraphs will not tally.
You are reading in SSC or you are reading?
I'm reading from Supreme today.
Okay, fine. Starts with the paragraph Parliament it manifests. Because it should be got it? Parliament.
No, I think the
Supreme
case.
today, right?
The legal position is thus, this is paragraph 73, 17. Sometimes even the paragraphs come in between. Ranjit Singh's case was no doubt dealing with that.
That Ranjit Singh's case is the next paragraph, I think, believe. And
Acha.
para 23,
Ranjit Singh is later. I mean, it's a later paragraph
after Ranjit Singh.
after Ranjit Singh. The power to award suitable sentences for several offences committed by offenders.
Next paragraph.
Ranjit Singh is a very big paragraph.
That comes to an end shall run consecutively.
We may now turn to
Okay,
the conflict.
read that paragraph.
Ranjit Singh Supra was no doubt dealing with a fact situation.
No, Ranjit Singh's case
Huh,
was no doubt dealing with the fact situation.
fact situation different from the one with which we are dealing in the present case. Inasmuch as Ranjit Singh's case was covered by 427. 427 is also similar to that of
Yes,
31.
that's right, that's right.
As the prisoner in that case was already undergoing a sentence of life imprisonment where he committed a second offense of murder that led to his conviction and award of a second sentence of life imprisonment. In the case
So
at
in
hand,
both the cases, Ranjit Singh's case, the accused was convicted life sentence.
Life
In the
both.
first case also, he was a murder, he was life sentence. The second case after getting in bail, he also committed a murder.
Yes.
Second case also, he was given a murder, so life imprisonment. So in both the cases, in Ranjit Singh's case, he was life sentence. So there, whether it is first life sentence and second life sentence, it has to be read together.
Correct.
So that's
Yes.
what is, read
Yes.
it, that will come.
Their cases therefore fall more appropriately under section 31, which deals with the conviction of several offences at one trial. 31(1) deals with and empowers the court to award, subject to provisions of 71, several punishments prescribed for such offences and mandates as such punishments, when consisting of imprisonment, shall commence one after the expiration of the other, in such order as the court may direct, unless the court directs such punishments shall run concurrently. The power to award suitable sentences for several offences committed by the offences is not and cannot be disputed. The order in which such sentences shall run can also be disputed by the court awarding such sentences. So also the court is competent in its discretion to direct that punishment awarded shall run concurrently, not consecutively. The question, however, is whether the provision admits of more than one life sentence running consecutively. That question can be answered on a logical basis only if one accepts the truism that humans have one life and the sentence of life imprisonment once awarded would require the prisoner to spend the remainder of his life in jail unless the sentence is commuted or remitted. That, in our opinion, happens to be the logic behind section 427 of the CRPC, mandating that if a prisoner already undergoing life sentence is sentenced to another imprisonment for life for a subsequent offense committed by him, the two sentences so awarded shall run concurrently and not consecutively. Section 427, in a way, carves out an exception to the general rule recognized in 427(1) that sentences awarded upon conviction for a subsequent offense shall run consecutively. The Parliament, yes, this actually it is in between the paragraph. The Parliament, it manifests from the provision of 427(2), was fully cognizant of the anomaly that would arise if a prisoner condemned to undergo life imprisonment is directed to do so twice over. It has therefore carved out an exception to the general rule to clearly recognize that in case of life sentences for two distinct offences separately tried and held proved, the sentences cannot be directed to run consecutively. The provision of 427 apartment Ranjit Singh's case, this court had in terms held that since life sentence implies imprisonment for the remainder of the life of the convict, consecutive life sentence cannot be awarded as human beings have only one life. That logic, in our view, must extend to section 31. Also, no matter, section 31 does not in terms make a provision analogous to 427(2) of the code. The provision must, in our opinion, be so interpreted as to prevent any anomaly and irrationality. So interpreted, section 31 must mean that sentences awarded by the court for several offences committed by the prisoner shall run consecutively unless the court directs otherwise, except where such sentence includes imprisonment for life, which can and must run concurrently. We are also inclined to hold that if more than one life sentence is awarded, the same would get superimposed over each other. This will imply that in case the prisoner is granted the benefit of any remission, commutation, qua one sentence, the benefit of such remission would not ipso facto extend to the other. Now, as for, yes.
31(1), CRPC, unless said concurrently,
Hmm.
it has to be read consecutive.
Consecutive.
That's
That
what they-
is settled.
Set-
But there are certain judgments where
Yes,
I've
right,
got that
that's right. but
one
this is-
transaction.
That's what in these cases, what been discussing, you see two different kind of incident, two
Hmm.
different incident,
Hmm.
not in one incident.
In the present case, that,
But here it is on the same incident,
huh,
he was tried with two different offenses.
Hmm.
One is under the POCTO Act
Hmm.
and the other is under the
IPC.
IPC.
Hmm.
So here what we have seen in the most of the cases, not only in the same incident,
Hmm. Yes.
here the cases decided are mostly in the two different incidents,
Ah,
including
yes.
the Ranjit Singh.
Hmm.
But this particular observation made by the apex court,
Hmm.
that unless it
Unless
is concurrent and it has to be read as
consecutive.
then of course in that case the accused have not completed the term.
Hmm.
They have to have 1.5 year more to complete. Will be completing in 2020.
But then if your lordships hold that it is one single transaction, then it has to be concurrent, few judgments are there.
Can we override this judgment?
That is of course.
Now, if you read that again, so the interpreted section 31, you just read it.
Hmm. And that is of course settles it. In fact, the section settles, but I don't know. There are few judgments of Cherian also. It was said, of course, that was referred. I think Cherian was referred
Everything has
here.
been referred. All the judgments
Uh-huh.
considered earlier
Hmm.
regarding the separate incident or the same incident.
Hmm.
Hereafter, this para has been incorporated. That
Hmm.
it has to be considered as consecutively unless
Hmm.
said in the
Concurrent.
judgment in the 31(1). So it cannot be considered as concurrent. But if it is written as concurrent, it will be concurrent.
It will be concurrent.
But unless if it is silent,
Hmm.
then consecutive.
Consecutive.
The shortest term first, then the longest term
Hmm.
later. It is not the longest term first and the shortest term. That's all.
So in our case also, he has to undergo some few more months.
Because few more.
Hmm. Sure.
We try to find out other cases also, as you have said, but thing is this 5 judges judgment, of course,
Hmm.
and that's
That our Honorable Justice Gogoi's judgment was Krishna Reddy.
Hmm.
There, of course, the charges, he was sentenced under two offenses, 344 IPC, child labor, bonded labor. And it was considered to be a same transaction and it was concurrent. It was decided to be has to be. in the-
since this judgment 2016 at SSC 313 is before you now.
Hmm.
Go through once again
Hmm.
because
2016,
conditions-
honestly, I have not gone through. That
go through.
Uh,
Go through and find out the cases which have
Hmm.
been cited by the Honorable Apex Court,
huh.
whether it is of the same incident
Hmm.
or of different incident.
Different incident.
If it is in the same incident, but that is what was disturbing because their lordships have said it 31(1), if it is not written concurrently, it has to be read with consecutively, and it's a 5 judges judgment.
Yes.
That's we cannot overlook that and say something that
Yes.
is of
5
the same
judges.
incident we have to consider.
Hmm.
You go through those judgments and you'll know, you just do that homework, that whether those in these cases referred by their lordships in this particular judgment refers to one incident or
Oh,
different.
different incidents. I'll go through.
If those cases relied by their lordships in this full bench judgment, in that case, the constitution bench judgment, and you will see if there are cases, because that is was little disturbing for us because 31 specifically mentioned, it's not written because they have said, the parliament have said, because definitely it has to be taken
Yes.
that way. So unless written concurrently, it will.
Has to be. That is actually the subtle position. Even Sunil, it is written that same transaction will not help. In fact, Sunil, it is written
That's right.
same transaction will
That
not.
is why the matter was referred to as earlier. This full bench of this constitution has considered that aspect.
Gotcha. But Sunil is 21.
Sunil is subsequent judgment.
21.
I think in Sunil's case also, they have
Yes.
this one.
Acha.
Home Syrian's case, I think so.
Muthurila Mingalam. Muthura Mangilam. Malingam. Perhaps
Oh,
they
in,
have.
Sunil Kumar's case also, this OM Syrian case 2015 has been referred.
Acha. I mean, yes. Sunil Kumar's case.
This is
Sunil.
2021 5 SCC, right?
2021 5 SCC 560.
No, 2021 5 SCC, if you come to para 7,
Huh. I think that Madhulingam 2016 judgment is referred by them. Ocheri and Gagan Kumar Nagaraj. Yes, it was referred in 21 case, Madhulingam, paragraph 7.5.
7.1 you come,
7.1 is on Nagaraja Rao,
read that.
Gagan Kumar.
Hmm.
It is obligatory for the court awarding punishment to specify whether they shall be running concurrently or consecutively. This is the contention. And the omission on the part of the trial court and the high court to state the requisite specifications cannot be allowed to operate detrimental to the interest of the accused appellants. The learned counsel has contended that though, as per the mandate of section 31, unless specified to run concurrently, the sentences do run consecutively, but for that purpose, the court is required to direct the order in which they would run. And no such direction having been given by the trial court or by the high court, it cannot be said that courts were consciously providing for consecutive running of sentence. Further, with reference to Cherian's case, the learned counsel would urge that it is not the normal rule that multiple sentences are to run consecutively.
Now here is a case. The court did not say which punishment will run first, which will later to be consecutive. Now, in that circumstances, counsel for the appellant there are good. These are the paragraph 7 point that continues. Points raised by the counsel before the court. Now come to the finding. Para 10.
The contentions urged in this matter essentially revolve around the provisions contained in 31(1) CRPC. The contours of these provisions have been succinctly delineated and explained by this court in Cherian's case. Under section 31 CRPC, it is left to the full discretion of the court to award the sentences to run concurrently in case of conviction of 2 or more offences. It is difficult to lay down any straitjacket approach in the matter of trial courts and appellate courts have invoked and exercised their discretion to issue directions for concurrent running of sentences favoring the benefit to be given to the accused. Whether a direction for concurrent running of sentences ought to be issued in a given case would depend upon the nature of offense or offense committed in the facts and circumstances of the case. The discretion has to be exercised along the judicial lines and not mechanically. Accordingly, we answer the reference by holding that 31 CRPC leaves full discretion with the court to order sentences for 2 or more offences and 1 trial to run concurrently. Having regard to the nature of offense and attended aggravating mitigating circumstances, we do not find any reason to hold that normal rule is to order the sentence to be consecutive. An exception is to make the sentences concurrent. Of course, if the court does not order the sentence to be concurrent, one sentence may run after the other in such order as the court may direct. We do not find any conflict in Dr. Hussain and
Then go ahead 10.1.
in Muruligan, this 2016 case, the basic question before the Constitution bench was to whether consecutive life, that sentence is not there, lives could be awarded to a convict.
Because all the cases related, it was a life sentence.
It was on life
That is why the 5 Constitution. So go ahead, it is there something.
in a series of murders for which he had tried in a single trial. In the course of determination of this question, Constitution bench dealt with several dimensions of sentencing, particularly those relating to multiple sentences and observe inter alia that 23.
Come to 10.2.
Yes. Thus, it is beyond a shadow of doubt that section 31(1) CRPC vests complete discretion with the court to order the sentence for 2 or more offences at 1 trial to run concurrently, having regard to the nature of offences and the surrounding factors. Even though it cannot be said that consecutive running is the normal rule, but it is also not laid down that multiple sentences must run concurrently. There cannot be any straitjacket approach in the matter of exercise of such discretion by the court, but this discretion has to be judicially exercised with reference to the nature of offences committed and facts and circumstances of the case. However, if the sentences other than life imprisonment are not provided to run concurrently, one would run one after the other.
The sets make court direct. Here is the question is court is the trial court,
No, yes.
right? The provisions of CRPC is different because there are high courts is there. And a court means the trial.
Trial court.
Depends upon the sections. So considering these aspects, probably because here also dear lordship that this matter has been discussed.
Mm, mm,
Muthuru Moralingam and then the constitution, we have to, as per paragraph 10,
mm.
it has to be consecutive.
It has to be consecutive, first blush consecutive. Let me go through 2016 as your lordship had said single transaction and
That is why, of course, this is 2021 judgment is there before you, but otherwise, go through that.
mm. Same thing as of course, it's consecutive.
then-
Yes.
We did not walk into that earlier action, but here it is before you.
Mm.
Let us see.
Then lordship will take it up tomorrow, day after or something, next
Take
week,
it on next Tuesday.
next
But,
Tuesday.
apparently, it appears to be, it has to run consecutive.
Mm. Apparently, yes,
It is, discretion is up to the
court.
court. But there is also a case where they have mentioned that if the matter comes before the High Court, High Court in the appeal can look into this matter. And
Achha.
instead of making it consecutively, they can pass an order to
Achha.
concurrent.
That will help rather.
That probably will go to that judgment. You'll see it is there, but they did not discuss anything elaborately.
Achha.
So they have altered the chain
Ah.
because it's an appeal. In the appeal, necessarily they can alter the
Yes.
sentence.
Mm.
So altering that sentence instead of consecutively, because there is no mention
Mm.
that it will run consecutively or concurrently.
Mm. But High
Right.
Court interpreted.
Because
Ah.
if, even in this judgment before us,
Mm.
there is no such that it will run consecutively.
Nothing.
There is nothing because sentence of 3 years
Mm.
and sentence of 5 years. So whether it is under 31(1), but
Mm.
that power is with the High Court in the appellate stage
To
pass
give
an
a
order
finding.
that whether it will run concurrently or
Or, yes.
that order can be.
That order can be in the facts of judgment. That judgment I've not found. I'll take out.
That's why I say it is very interesting that way. Otherwise
Mm.
things will be different.
Yes.
Normally we know that unless it is concurrent,
It is
then by a trial
consecutive.
court, but the appellate court has the
Power to
look into.
give a finding.
Okay.
Mm. Gotcha.
May I please, your lord? Lordship, may I kindly be allowed to mention item number 25, lordship?
What kind of mention you want to make?
Lordship, actually, we have an instruction from our client to withdraw this matter, lordship.
You want to withdraw, your petitioner want to withdraw.
Yes, lordship.
Yes, it will be on next Tuesday or Thursday.
Tuesday, I'll inform KP for that. Next Tuesday?
Let us see. Okay, Tuesday.
Tuesday. Got it.
What's your good name?
Yeah, Brahma, lordship.
Pardon, Mr. Abraham, but where is the other council? Anyway. What on? 19/08/2020. The personnel from DRI in presence of witnesses recovered two zero two 0.75 kgs of ganja in bucket cannabis from a Tata truck bearing registration number AS01 PC AS-01 DC 0792 in DRI case number 03 CL NDPS ganja DRI oblique ZZU oblique 2020-21 in 14 packages. For contravention of the provision of section 8 within bracket small c of the NDPS Act 1985, punishable under section 20 within bracket small b within bracket small Roman 2 within bracket small c, comma 23, comma 27A and 29 of the NDPS Act 1985. Wherein the petitioner, wherein they say DRI case number already. The DRI officers, after investigation, submitted a search sheet in which petitioner was shown to be an absconder accused. For his appearance in the case, Tara Patel said DRI case number such and such. He recovered the recovered from a truck bearing registration number such as section at corridor that was parked in the service lane near Eastern Road ER Carriers. National Highway number 37, back to C. Opposite to Honda showroom at Guwahati. Filing of the search sheet in the case. Say DRI case number 03 pura likhi diba. Has been registered as NDPS case number 09/2021. Is pending before Planet Special Judge NDPS.
So it is now transferred to additional number 3 law.
Yes, I get it. Presently pending before additional district and session judge number 3, Kamrup Metro at Guwahati. The said NDPS case number 9/2021. And on a trial court issued non-bailable warrant of arrest against the petitioner for his appearance. The petitioner filed his criminal petition, praying amongst others to pause the entire criminal proceeding of said NDPS case number 9/2021 within bracket Union of India versus Nazrul Islam and 4 others. Notice in this case was issued on no notice is for- Notice have not been issued, I think so. Notice was, but it was admitted for hearing. Yes. Okay, notice was not. Let's see another fact in this case. The case is fixed on 31/7/2024. In the meantime, non-violable warrant has been again issued against the present petitioner. But petitioner wants to withdraw this case. No, Lordship, I cannot object, but this is a fact. He's defaulting before the trial court also. And out of 10 witnesses, only one has been examined so far. But here is no point. What is there? This criminal petition was admitted for hearing by order at the 26/10/2022. However, on instruction of the petitioner, Mr. A. Brahmo, learned counsel, is not pressing this petition. To which Mr. S. C. Kyle, understanding counsel DRI, has no objection. Accordingly, this criminal petition stands dismissed, being not pressed.
Much obliged.
Heard Mr. S. P. Chaudhary, counsel appearing for the petitioner, and Mr. K. Bushra, learned additional public prosecutor for the state testimony number 1. Also heard Mr. S. Day, learned counsel for the respondent. Brief facts of the case is that on 27/07/2020, the respondent number 2 got married with the petitioner. The response number 2 on 1908-2020 lodged an FIR before the officer in charge of Silchar police station. Response number 2. Number 2 लिखते हैं ना, Commander who is the resident of Mohanpur Road under Srikona outpost of Silchar police station. Married to the petitioner, resident of Silchar district Kacharpur. Jaipur Raja Bazar under Jaipur police station of district Kachar. Married to husband of petitioner, resident of Sattara on 27/07/2020. Okay? On 19/08/2020, the response number 2 lodged an FIR before the officer in charge of Chhattisgarh police station, alleging that though she lived with the petitioner as husband and wife after their marriage on 27/7/2020 in her matrimonial home, the petitioner failed to perform his conjugal rights because of his physical disability. But the said respondent remained unrepresented when the matter was taken up for consideration. Please don't. Next to the suitability. 25th. Okay, we'll have it next Thursday.
Lordship, CD to be retained till that.
You have received a CD or it is a scan copy?
No, Lordship, it is the CD, Lordship. Not scan.
You retain it.
Lordship.
Only the scan copy was called for. Why you are holding it? Yes, next.
May I please, Your Lordship? Lordship, there's a criminal division, Your Lordship, challenging an order, Your Lordship, at case number 10, Your Lordship. It was an order, Your Lordship, where, Your Lordship, the Jimma prayer of a vehicle has been rejected, Your Lordship, by SDJM, Your
Ms.
Lordship.
Jahan,
Lordship.
Zimma matters, so law is settled. Why I don't know. Then, the report was called for. What happened? Did you receive?
It was there, Your Lordship. I'm the rightful owner of the vehicle, Your Lordship.
Okay.
Report is not there today.
No, report was called for.
Acha.
Okay.
130 days, Your Lordship. I'll get it. I'll get 2 times.
See,
certificate.
yes, on 4th of June it was called for.
Yeah, Lordship. And
And again, 28th of June it was.
Yes, Lordship.
Dekha. Third MSD Board of Council appearing for the petitioner. And MS as the Handland Additional Public Prosecutor for this state. Matter relates to Jimma of the vehicle bearing number AS01-FM public 6628. What kind of vehicle?
Kia Seltos, Your Lordship. That is the RC, your lordship. Yes, self-post, your lordship. 12 page number. It was a recent certificate, your lordship.
Rejection order, rejection order.
Rejection order is case number 10.
Case number
10.
10 now.
It is Seltos,
Self-post, your lordship.
the Seltos vehicle. Bearing registration number circle. Seized in connection. When it was seized,
It was on 7 March, your lordship, 24. 130 days, your lordship,
seized on.
in the police station.
03.
It is hard to believe that they will bring animals in a cell.
No, no, lordship. That is not the fact, your lordship. If your lordship kindly see the FI.
No, it's a fact. They are bringing animals in Centro, Alto.
That is
I'll be
the
very
fact.
surprised.
Very surprising.
But in this case, that
Had
is-
it been a truck, okay, we could have understood.
No, it's
No, no,
happening.
in this case, your lordship, this.
Because during my last visit to this as a portfolio that I visited Nagaon, Tinsukia and others, there we got the information.
Lordship.
They're bringing everything.
My
In
God.
Nagaon, so anyway.
Anything is
So-
possible.
In my
Seized on 7/3/2024 in the Saigon PS case number 45/2024.
এখন গাইড কৰিছো বুলিহে কৈছে।
অ,
এতিয়া
হয়নি?
লিখা নাই।
এইখন পিছত আহি আছে।
এখন ইউজ কৰা নাই।
Legislation carrying cattle. This is the vehicle itself, LLP carrying cattle. Narcotic seized under section 13 in bracket 1 of the Assam Cattle Reserve. The learned subdivisional judicial magistrate within bracket M. Gosaigaon on 22/04/2024 resurrected Jimma of the vehicle on being trained by the petition. Hence discriminatory. By order dated 04/06/2024 and 20/06/2024, report passed earlier by this court called for the report from the concerned investigating officer of said Gosaigaon case number 45 of 2024 as to whether the said vehicle bearing registration number AS01-FM6628 is required further for investigation of the said Gosaigaon case.
ফোন কৰি আনিব লাগিব।
On being inquired,
আপোনালোকৰ report নাহে।
Ms. Zahan and additional public prosecutor submit that
ঠিক গুচাই গাঁও ন?
the same has not yet been provided by the investigating officer of Gosaigaon case number.
গুচাই গাঁও।
Issue reminder to the investigating officer of Gosaigaon case number for such report. Failure on the part of the investigating officer of Gosaigaon case number to provide the report that was called for by order stated 46. The court shall consider to pass consequential order against the erring personnel placed on
Next week I'll get it.
31st.
Lordship?
31st.
31st. I'll get it. Positive.
Copy of this order will be furnished to MSS for notice.
Make please your document.
Why does this from the orders?
My lord, as per the office note dated 13/6/24, my lord, notices were issued on the respondent numbers 3 and 4, my lord. They are the accused number 1 and 2. My lord, and as per office note dated 16/7, the SR for respondent number 3 and 4 are not received back, my lord. Even the scan copy of the records are not received.
Four has been received back, I believe.
My lord, as per what I saw, my lord, office note 16/7 says, my lord, SR for number 3 and 4 not received back from District Magistrate Kamrup Metro, my lord.
Matter be placed before the what did you take step?
My lord, 7/6, though it is not reflected, my lord, in the CIS, I can see, my lord, 7/6/24. My lord, we had
Shall
taken,
we place it before the Lozima court?
my lord, may.
Because
Service has to
they'll
be
able to get the report whether it has been served upon 3 or 4 or not.
Yes, my lord.
What's your good name?
My lord, A. Bhatra.
Counsel for the petitioner. And
Also P just for respondent number 2.
MSS online additional public prosecutor for the respondent. Also heard Mr. P. Das and counsel for the respondent. Matter be placed before law. For necessary verification and matter notice and serve and to furnish that.
My lord, interim order was there, my lord, definitely.
List on 9th of August. Till then, the interim order passed earlier on 11/8/2023. 8th of August shall remain in.
Highly obliged, my lord.
Yes.
Good that you have joined the profession.
My lord.
Good that you have joined the profession.
My lord.
At least the court will be benefited with your experience
My
in the
lord.
judiciary.
I will try.
Welcome. Yes, Mr. Chandak.
My lord, today is fixed for, getting a scan copy of the testimony of PW1. As well as we took steps for not issue some notice on the respondents.
Sharma. এই এখন নোটিফিকেশন ওলাইছিলে 17th March. আছে নেকি? 15 March. Notification number 17.
Notice to
15 March,
Recalling that was rejected.
notification number
Recall-
7 relating to issuance of notice of
Rejected very taller court. No.
This is for that's why this revision petition.
No.
I was told that notice was.
Oh, I mean through the registry. এটি কি টুটার রেজিস্ট্রি है ना?
সিস্টেম আছে
না আচলতে রেজিস্ট্রি আমাক দিয়ে
আচ্ছা আচ্ছা
আপুনি আমাক দিব নালাগে
আচ্ছা।
আপুনি ৰেজিষ্ট্ৰি দিব অ
বেশি কথা
Mistake of the council cannot be a ground for recalling. That was the ground for rejection.
Okay. Petitioner shall serve a copy of this application along with the annexes appended thereto. The public prosecutor obtaining necessary acknowledgement on or before 23rd of July, obtaining necessary acknowledgement. Thereafter, the office of the public prosecutor shall forward it the same to the officer in charge of Bhatikam Police Station who in turn shall serve the copy of this application to the respondent number 2, informant of the case, namely Muhammad Azad, son of Samimullah, Samiullah, Samiull, resident of Izubari, Bihari Bosti, Police Station, Hatigaon District, Kamrup, Guwahati. Hatigaon, Guwahati District, Kamrup. Number 10. List obtaining necessary acknowledgement list na? List on. 12th of August. Report.
Thank you.
Issue reminder to the learned sessions court. The Red Court of Additional Session Judge from Special Judge Boxo Kamrup Metro Guwahati for the scan copy of the deposition of the prosecution witness number 1 in why it is not a POXO case and Sessions case. Anyway, Sessions case number 39/2019 pending before it has been called for by order dated 20/06/2020. ठीक है? List on, list on for this.
I have, can it be fixed on any Thursday or Friday?
You want Thursday and Friday?
Yeah. 9th or 16 or like 16 August. Or 9th August.
13th isn't difficult. 13th August is a Tuesday.
Tuesday.
Possible?
Only any Thursday or Friday.
Thursday or Friday you
Yeah.
want?
I'm having classes.
Oh, you are there. 16.
Okay, obliged.
Yeah.
No problem.
May I please Lordship? Lordship, service upon respondent number 1, Lordship, is still awaited as per office note dated 16/7/2020, and also LCR has come.
Appeal against secretary, no division. Acquittal against her. Hmm. Oh, oh, they have sent remanded for additional evidence. Hmm.
Await service report on the respondent number. Where is the office note dated 16/7/2024? Where is the service report on the respondent number 1? It's a reminder to the SL additional session judge number 2 at visit in Chukia. For the scanned copy of the records of criminal appeal number 02/1/2021, as well as the learned additional CJM in Chukia for the scanned copy of CR number 125C/2014 has been called for by order dated 25/06/2020. Sarakote part Mr. Tikki, counsel for the petitioner, and I'm Mr. Jahan, Lade District Court, Prosecutor for the report number. Placed on 28th of August.
Public. Please, your lordship. My lord, Mr. N. Hoffman is unwell, my lord. He's the conducting counsel. He has asked me to speak for an adjournment.
On the prayer of Mr. Hassan, counsel for the applicant, there is a holiday. When
Next week, my lord.
list after you on a date to be fixed by the
Deeply obliged.
where an objection has been filed, this is a, okay. That's a testing.
We have to file an objection to this.
In the meanwhile, the state responded, self-file its objection.
Right, my lord.
Pertaining to welfare of the applicant.
Hi, Lordship. I will, Lordship, application for 82 of CRPC for quashing and BWA, Lordship.
Today it has come up for orders, your answer. Records have been received perhaps because of that. NBW.
NBW. Only 3 days.
For this prayer, we need not have records. NBW for
NBW.
order sheet. Order sheets available. Order sheets available.
Exact.
Mm. Mm.
Who was the complainant? Respond number 2 was the complainant or what?
Afroza
Yes.
Chaudhary. Case is 302-120B.
But nothing is against me in the FIR as well as only arrested on the statement of the accused Krishna Das, main accused. And already 5 witnesses are examined, nothing is against the petitioner.
His prayer is only for quashing of the non-bailable warrant, those orders. So what Lordship can do is direct him to appear on a particular day and NBW
He may be
maybe,
given an opportunity, Lordship.
NBW may be
Maybe
kept in abeyance for
Let us say that because that order we're looking for.
Is or not answer, yes.
9 April of 5. Still NBW pen.
అవునా ఒకటి আপনার আরো মানুষ আছে কিন্তু ট্রায়াল করে দিও আপনার কেস ফাইল
না বড় চলে এসেছেন কিন্তু আপনার এই 9 এপ্রিল 2024 ফাইল করি আমি স্টিল NBW pen 9 10 2023 অ্যাকশন আসলে পূর্ণ ফর্ম thereafter 20 and form and voting of it that was of fixing. Just not happy with that.
can go in again and we can find it.
You are absent since when? You did not appear before the court when? Since when?
Lordship, on 19/12/2023, NBW was issued. On 19/12/2023, NBW issued, as I could not communicate with the landed council as a mobile phone has lost. And thereafter on 29, Annexure 2, Lordship, and Annexure 3, page 19, on 29 February 2024, again NBW issued against the petitioner and issue notice to the landlord. Lordship. Thereafter, the petitioner communicated with his counsel, but he informed that already in 19/12/23 and 29 February 2024, NBW was issued says on apprehension of arrest and sent him to judicial custody. He was not appeared on 9th April, Lordship, 2024. And on that day, the case was filed against the petitioner. But the NBW is still pending. Lordship.
There will be more orders before this 22
What
order.
happened on 4th July? When is the next date?
Or the next date is 16 August.
What is the order passed on 4th of July?
Court of
You are already declared as a proclaimed offender. Right? What order was passed on 4th of July?
4th of July 24.
How do you know that the next date is the 16th of August? Do one thing. What's your good name?
is
File a 2-page affidavit by Saturday, either by you or by your clerk, incorporating the order passed by the additional session judge number 1 Kamrup Metro in session case number 36/19. The matter is fixed on 16th of August. The order, you will get it in the website, right? Type it down or get a scan copy and place it. You pass the order. File the affidavit. We'll take it up on
Annexing
Tuesday.
all the order sheets.
Got it? File an additional affidavit, praying that that same to be read along with this petition. We'll pass the necessary order. We'll allow you to appear. You want to appear, right?
yes, Lord.
Okay, we'll pass the order. We'll do it. What's your good name?
Is
For the petitioner. It appears that the informant is a lawyer, practicing lawyer.
Acha.
Her husband was found dead,
Afroza Chaudhary.
and
No, not
mother of the deceased husband of the petitioner, or as well the informant, filed a petition,
Acha.
and that's how before the police accountability,
Okay.
that's how the order was registered and the case started. Anyway,
He will appear, he said. He'll have to appear.
and MSS Jahan Lal, additional public
Capital
prosecutor.
Library.
Petitioner
Noor Alam.
is allowed to file an additional affidavit in the matter on or before when? By Saturday, only 2-line affidavit to bring in on the record.
Kindly by fix 25.
Why? About the order
22nd.
passed by the additional session judge number 1 Kamrup Metro Guwahati in session case number 36/2019 on 04/07/2024. List on Tuesday quality 23rd. File a small affidavit either by you or your clerk, that's all. We'll pass the order. Okay, listen it. Listen it.
अपनी ऑर्डर तो फाइल कर लास्ट ऑर्डर तो लेगा
Lordship, the arguing counsel was not feeling well, so she left. But the brief was not with us. Although I am there in the case, let this matter may come up tomorrow, Lordship.
I have filed Mukalanama, Lordship, today, Lordship.
You have appeared.
Yeah. First, number two,
What's your
Lordship.
good name?
GG Google, Lordship. And agenda matter for today, file affidavit in opposition, Lordship. After 4 weeks, Lordship. I don't know.
Order makes a battle of 100 counsel appearing for the petitioner. The MS makes a harm done in the prosecution. For the state respondent number 1. Mr. ZZ Gogoi, learned counsel for the learned counsel has an appearance on behalf of the respondent number 2 by filing the necessary occult number today. Registry shall reflect the names of the counsels for the respondent along with other counsel in this manner. Service of the service is completed. Release this matter after a week. Release this matter after 2 weeks on a date to be fixed by the registry. In the meanwhile, the respondent number 2 may file its affidavit slash objection if any in the matter.
Much
Thanks. Lordship, item number 22, interim order is there, my lord.
Does not reach, so 22.
20, interim is there, my lord.
This is MPMLA's matter which has to be heard.
Till today,
Till the returnable.
I think it is the until further order. We'll look into it. If there is order, we'll tell you.
Okay.